There were 2 questions on one note.
Right.
This is number 4. Okay. All right, this says, can the jury review the dash cam video at the apartment? Yes. So, Mr. Dwayne, get that queued up for me. I will note that this note is not from the person who was identified as the foreperson initially. I don't know that it matters particularly, but I think that I'm going to advise them to, that the foreperson needs to communicate each juror's request to me going forward. Does anybody have any objection to that? I think that's just proper. So I'm just going to say we will get that set up.
Maybe somebody else is taking over.
Maybe this, you know, so. I just wrote, we'll get that set up. Communication should be from the foreperson. The foreperson should communicate the rest of should communicate requests of the other jurors as well.
Yes, ma'am.
Again, I don't think it's significant particularly, but it is. I don't usually. Take that note back to them and tell them we're getting the video set up. We'll pull them out in just a minute to watch it. Yeah, they don't need to come in. All right, y'all be seated. The jury has sent out a note that they are deadlocked. They did not include a count. I am inclined, obviously I'm going to Allen charge them. I am inclined to ask them without which way, but just ask them for a count. Because I think it matters if they're 6-6 or 3-9 or what have you. Or I can just read the Allen charge and we can wait on that.
If we are to inquire as to the count, I think we should also inquire in the count, meaning what the vote is between the 12, as to if it's specific to a count, if they have reached a verdict on any count.
I agree. Are they deadlocked on all 7 counts? And if so, without telling me which way, what is the count? Are we comfortable with that?
Yeah, what is the vote for count?
What is the, yes.
And Judge, I'm okay with that. We did that with Judge, on occasion I had Judge Adams. It's the first time that, because the foreperson of the jury volunteered what the count was.
Right, and sometimes they do and sometimes they don't.
And I don't have a problem.
And it is certainly improper for me to inquire which way. I just am interested, because I think in evaluating how much longer I ask them to deliberate, that is relevant information for us to consider, and whatever, however y'all want to proceed. So. All right, it just says, are you deadlocked on all 7 counts? And without telling me which way, please tell me that count. By that, I mean how many one way, how many the other way. Does that make sense? All right, let's send that out and sort of see where we are. I'm going to pull up the Allen charge. I know that there was, at least as to some counts in some opinion yesterday, a juror who had indicated that they were not going to change their mind, but I still think it is probably appropriate to Allen charge them before we make any decisions. Accounts, the numbers are not the same on all accounts. They range from 11 to 1 to 7-5. So I'm going to Allen charge them and we'll see. But it sounds like count 1, they're 3-9, count 2, they're 4-8, count 3, they're 9-3, count 4, they're 11-1, count 5, they're 7-5, count 6, they're 7-5, count 7, they're 11-1. So bring them in for me, please. Ladies and gentlemen, you've now been deliberating on this case for a period of time, and I think it's proper, based on your notes to me, to advise you further in regard to the desirability of an agreement if possible. The case has been exhaustively tried by both sides. It's been submitted to you for decision and verdict if possible, and not for disagreement. It's the law that a unanimous verdict is required. And while this verdict must be the conclusion of each juror and not a mere acquiescence of the jurors in order to reach an agreement, it is nevertheless necessary for all jurors to examine the issues and questions submitted to them with candor and fairness and with a proper regard for and deference to the opinions of each other. A proper regard for the judgment of others will greatly aid us in forming our own judgment. Each juror should listen to the arguments of the other jurors with a disposition to be convinced by them. If the members of the jury differ in their view of the evidence, the difference of opinion should cause all of them to scrutinize the evidence more carefully and re-examine the grounds for their opinions. Your duty is to decide the issues submitted to you if you can conscientiously do so. In conferring, you should lay aside all mere pride of opinion and bear in mind that the jury room is no place for taking up one side or the other of a cause or maintaining a spirit of controversy either side of a cause. You should bear in mind at all times that as jurors you should not be advocates for either side. You should keep in mind the truth as it appears from the evidence examined in light of the instructions of the court. I'm going to ask you to retire to the jury room for a reasonable time, examine your differences in a spirit of fairness and candor, and try to arrive at a verdict. I will also tell you that if you have a verdict on some counts and not other counts, if you will notify the court of that. All right? Thank you, ladies and gentlemen. I'll ask you to step back to the jury. Oh, wait. One other thing. We had some discussion, the lawyers and I had some discussion in chambers about whether or not they were entitled to know the count, well, which way the count was going, based on the note that the juror sent out. I'm going to stand by my ruling on that issue, and in doing that, I'm referring to, I'm relying on some language in Smith v. State, which is a Supreme Court case, 302 Georgia 717, which also references Sears, which is 270 Georgia 838. So just for the record, I shared all of the contents of the note except for which way the count was going, and candidly, it was not identified using the terms guilty and not guilty, but was identified in other ways from which I think that is would be the only conclusion the parties could draw, and I don't think that's proper. But I did share the count as the discharge, which I think the parties are entitled to know, and we've responded accordingly. So let's make sure that light's off every time we take a note from them, and we'll stand and recess until 1:30. And y'all make sure you're back so that we can play that video as soon as they're all back. So maybe a few minutes before 1:30 in case they're fast. Let them go. That note tells them that.
Did they respond to your question?
Yes, I'm sorry. They said that possibly on count 7, not on arrest, but I should have read it out loud. I'm sorry. I was thinking about the medical issue. I want to make sure that's not emergent. I did not think that it was, but they're real need of a break. It's the way that was communicated to me. So I won't let them do that. Mr. Bob, bring that last note back to me, please.
I'm sorry, I'll get it back.
Okay. You go to the and take a break, and so bring that note and note what the medical record is.
Is that juror still back there? You want me to send her out?
All right, so counsel, I'm sorry for not, this is the last note that I did not read. Number 1, yes, we do need a break. 2, it is possible to get on count 7, nothing else. The rest, no. We will need to address the medical issue with one juror. Need a break first. Exclamation point. Okay.
Here's
You know
the
what
other
number we're on?
the ladies and.
Yeah, okay. Is it 10 and 11? Okay. I'm going to ask the juror with the medical issue to write that down for me so that they candidly have nothing to do with which juror it is. And we'll just do that. And
find her.
While she's doing that,
Oh, good idea.
and I've just written, please share your medical issue. I don't want to bring you out unless necessary. Give that to her. Counsel, while we're waiting on that, what do we think on the deliberations?
As it relates to what?
Do you want them to continue? Are you asking me to declare mistrial? So they told us they were deadlocked fairly quickly this morning. They were out a couple more hours. They watched 2 additional pieces of evidence. They were out another 30, 45 minutes after the second piece of evidence. The foreperson indicates the only movement is on 1 of the 7 counts, and that he characterized as possible, not on the other counts. Mr. Groove?
Judge, our position is we would ask the court to grant a mistrial in this case.
All right, Mr. Dwayne?
Well, we had an indication from regardless of what's happened in the past, now they're saying we might be able to reach an agreement at least at 1 count. But we also are waiting the note back from the ill juror, because if the ill juror has to be removed from illness, then we're starting back over again.
I mean, that would be, our position would be, of course, if you're pleased, if 1 juror is to be removed, then they have to start completely over as to all counts.
Right. And then the question is, well, and I guess it depends on, this is a 7-count indictment. And my recollection is at least 6 of the counts were almost evenly split at the last discussion, including, give me that note back, please. And count 7 last time was an 11-1 count. So you're still, when we talk about are we making progress, that is where we are on that last count. I think it's necessary to hear from the other juror before we make a decision. Probably. Mr. Dwayne, is there something else you want to add on the record?
I am interested in what the response is from the juror.
Will you please step in there and ask her to just say the judge wants to know if you are able to continue? Well, never mind. Okay, let her take a break. Or him, whichever, that juror, I don't know. Counsel, if y'all step up, I don't see any need for this. All right, based on the information shared by this juror with regard to their medical issue, it is not something that the court finds at this point or that the jurors requesting would require substitution. They just needed a break. I think it was more to emphasize their need for a break than that there was a separate issue, which I didn't understand clearly. So the defense has made a motion for mistrial. Mr. Dwayne, I'll hear any comments you have.
At this point, Your Honor, if based on what they're telling us is accurate as to count 7 and the other counts, I don't see us going really anywhere meaningful at this point. So I think at this point the court probably should grant the mistrial.
All right, I think it is proper to do it with the jury present and for me to inquire on the record whether they're able to reach a verdict or not. So we'll give them a few minutes to get instead and come back up and then we'll see what they have to say at that time, and barring any additional information, that's probably where we're at. But we'll let them finish their break, and we will wait and inquire at that point and go from there. All right?
Thank you.
So y'all just kind of hang out in here a few minutes while they're up in a break, and then we'll go from there. All right. We'll stand in recess till, let's say like, I told them to try to keep it to 10 or 15 minutes, so hopefully 5 or 10 minutes because we've been talking.
All right.
All right, this is my proposed note. Do you believe further deliberations are likely to result in a unanimous verdict on all counts, some, or one count? Can you share the current count without telling me which way, just numbers? And I'll put as to each offense so that we have some idea of what we're dealing with. Because obviously we want a verdict if we can get one, but they have now essentially been out a significant time considering the time it took to present the evidence. And so before we ask them to come back on Monday, I need to make sure that we have done everything. Or before we send them home without a verdict, I need to make sure. So we want to make sure we're doing all the things.
And once again, we would stand by our motion.
All right. All right, in answer to my first question, the answer is no. Do you believe further deliberations? So then I asked for the current count. I think what they've done is give me the count on, well, I don't know what they've done. They've given me numbers, that don't add up to 12 on 2 of the counts. So I'm going to inquire further. So I just said on these counts, do you have a verdict or what is the math? Okay. No, I've not seen this. Okay, they have sent this note that the bailiff just handed me, says jurors have stated we will have the same result on Monday, no further deliberations are needed. So, based on that, I'm going to declare a mistrial and excuse this jury. If you will get the alternates and let me bring them in and just give them some final instructions, and we'll release them. I don't know what the release is. 13. Hang on to the alternates for me, okay? I think. Ladies and gentlemen, as we've discussed, a verdict in a criminal case needs to be unanimous. As you are unable to reach one, I'm going to declare a mistrial in this case, and this will complete your service for the week. You can leave your buttons behind, leave your notepads in your chairs. You just tear those up and shred them. Nobody's going to read your notes or what have you. The clerk will have a check for you that will have a stub that will prove you were here Monday, Tuesday, Wednesday, and Friday for your employer. If you need something additional, you can contact the clerk's office or my office and we'll let you do that. I told you about 50 times not to talk about the case or let anybody talk about it with you. At this point, you may talk about the case if you wish. You're not required to, but often the attorneys may want to know what you found persuasive or didn't find persuasive or what have you. So I always let you know that it is not improper anymore for you to talk to whoever you want to about this case and your service on it. You are, of course, in no way required to do so. Make sure you get all your personal items. Leave me my buttons so I can recycle them for the next group. And Mr. Davis will show you out. Mr. Bob will show you out the back door. Okay? Thank you, ladies and gentlemen.
just leave them in the seat?
Yeah, that's fine, we'll pick them up.
Do you find them one?
All right, did we set a date in the other one?
November sometime.
So that's gonna be my first available for a retrial. The state will need to decide whether you want to retry this one on those dates or, try the charge co-defendant, if you're going to retry the matter. Just be thinking about that so we can get scheduled. This is the oldest case on my docket, so I'm going to push in to get it retried again, okay?
Will you issue an
All right.
order on the mistrial? Will you issue an order on the
I
mistrial?
will, and I'll do that before I leave. All right, we'll stand in recess. Hey, and y'all, Miss Montgomery is deserting me, so if you need a transcript, tell her now.
All right.
Can you make sure she gets out to record?